Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics, or are your politics starting to shape your faith? In other words, what do you do when God and government come face to face? I'm your host, Orland Johnson. Let me introduce you to our guest panelists for today. First, we have Ms. Bettina Krause, who's the editor of Liberty Magazine. We have with us Mr. Tim Schultz, who's the president of the First Amendment Partnership. We have with us Mr. Andre Wong, who's the general counsel of the North Pacific Union Conference of the Seventh-day Adventist Church. And we have Mr. Rashawn Baker, who is the president and CEO of the Baker Strategy Group and University of Maryland professor of public policy. Great to have you guys here with us. Looking forward to our conversation today. You know, a big question that we're seeing in politics right now is how religious institutions are viewing the separation of church and state. You know, the issue regarding the separation of church and state has been prompting much debate. But in spite of all of the rhetoric, many historians believe that the America's founding fathers did not seek to eradicate religion. Matter of fact, there was an overwhelming majority who signed the Declaration of Independence that counted themselves as being religious men. But it may come as some surprise in the Constitution that there is nothing in there that has the words separation of church and state. This idea kind of came from a pen of Thomas Jefferson, and then many other groups had decided that they wanted to talk about it. We've seen court cases, but the fact of the matter is one of the defining principles of how we do things as it relates to the First Amendment revolves around this particular phraseology that doesn't exist anywhere in the Constitution. You know, Tim Schultz, in much of the work that you do, I'm sure this comes up all the time, but when we think about the fact that our government is supposed to be a republic and not a theocracy, are we really where we need to be regarding separation of church and state, or do we see a society that now is trying to pull that concept apart by the seams?
Well, this is a pretty complicated question, Orland. I'm going to just kind of give a couple thoughts. One is that the Constitution doesn't use those words, but there are two First Amendment clauses in the Constitution: no establishment of religion and the free exercise of religion. And I think over time, I think the idea of a separation of church and state is a pretty good proxy idea for something that the Constitution does enact, even if it doesn't use those exact words. Okay, so I think that there is, and even the scholars who think that the courts have gone too far in one direction, an anti-religion direction, usually acknowledge that there is something like the separation of church and state that is embedded inherently between those two religion clauses in the First Amendment. At the same time, I think that there was an era in American history where the Supreme Court especially started to see religion a little bit like we see asbestos, as something that's inherently worrisome, that shouldn't come anywhere near government, and that we ought to treat it almost like asbestos. And I think that was based upon a faulty notion of separation of church and state, this idea that there has to be a high wall. And that I think resulted in religion being consistently treated worse by our courts than lots of other philosophical value systems. So religion alone was treated as dangerous. And I think that also sort of made a cultural idea that somehow religion has to be separated from the business of government. And that is also not true, obviously. We wouldn't have had the civil rights movement without the morally infused, but, quote unquote, theocratic understanding. And it wasn't theocratic, right? It was a view of the common good that was informed by the moral sentiments of Christianity and the civil rights movement. So I think that, are we at the right place now? I think that we're moving toward the right place. I think that there are obviously always theocrats around who want to sort of completely say there's no separation and that we ought to have Christianity. That, I think, is also wrong. But I think that there's a balance there, and I think it's important to kind of have a cool head about this and understand that there's truth to separation of church and state, but like everything, it can go too far in either direction.
Yeah, I agree totally with what Tim said, especially in the first part of it. I think if you look back in the founding of the Republic, Thomas Jefferson and James Madison and many of them, John Adams, worried about the actually persecution of religion, which is why they wanted to make sure there was this separation of church and state, that no one religion would dominate. They saw what was going on in Europe and other places, and they wanted to keep America away from that. It's interesting now that we've now come to this point where, since we are, for the most part, a Christian nation, the worry by some, and myself included, is that we're going far. We went away where there was no connection of government and religion, which is not right. As a former legislator, I can tell you that. But we've now gone to where people are, the fear is that we've gone too far to the other extreme, where we're becoming a Christian nation and therefore could impact other religions or those who have no religion.
Bettina, what's interesting is that the battle seems to be not the government pushing to kind of eradicate this concept, but leadership in churches seem to be the ones that are pushing to say, we want to be more vocal. We want to get involved. Why are you keeping us out of the game?
It's interesting, Orlin. I agree with what Tim has laid out, and also Rashawn. I mean, there is this balance that needs to be kept between the relationship between church and state. But the folk who are really pushing to erode that a strong legal separation between government and religion, let's face it, they all belong to one religion. They belong to the majority religion. And I think that in itself speaks volumes, because this interplay between religious free exercise and separation of church and state that makes our constitutional regime unique and so effective in protecting a pluralistic society. I mean, that is being eroded. It's becoming lopsided. The Supreme Court is moving more toward empowering the idea of religious free exercise. It's eroding this idea of meaningful church-state separation. And when you have that lopsided balance, I think religious minorities especially have reason to be concerned. I mean, let's face it, the past 250 years of the grand American experiment in religious liberty, that's just a blip in the vast sweep of human history. Freedom of conscience, choosing your own religion, if you had tried that in any other point in history, it would probably have led to a very messy death. So let's not play fast and loose with this finely balanced interplay between these two clauses.
But Andre, maybe after 250 years, the idea of how it used to work before and what a church and church institutions and organizations look like today may be vastly different. Is it time maybe that we start looking at it differently? That, yeah, I might be the pastor of a huge church, but I'm still a citizen that wants to be involved, but I just so happen to be influential.
Yeah, and I go back to what Tim said. I mean, I think we're doing the best with what we have. And, we have a balance between allowing religious expression in civil life, but also keeping policymaking secular. And a secular government can ensure that no single religion dominates public life while still allowing all faiths to be practiced freely. So coexistence does not require religious influence over policymaking and legislation, but nor exclusion of religion from the public square. Government does not dictate theology, and religion does not dictate policy. So, in my opinion, what the founding fathers had as this experiment, this idea, is that religion can offer moral guidance. Right? That religion can align with government goals, such as encouraging civic responsibility. But at the same time, governments can protect religious freedom and ensure religious pluralism.
If I may, Orlin, I think I've agreed with all the panelists, and I think I'm going to take the liberty here, because this is my full-time day job, to just maybe talk a little more than I normally would. One thing is that what is different now than at the founding is we're a much bigger and more complex country. We have an administrative state. We have regulations. We have the government involved in a lot more things. That's, I think, necessary to go from a kind of frontier country to the modern economy that we are. So that's just a fact of life.
Yep.
And I think that when that occurs, you're going to have government rubbing up against the prerogatives of churches and faith-based institutions in a way that they wouldn't have, at the founding. And I think we just need to recognize that the principles that were enacted in the Constitution are correct. But you're right, we're in a different situation now because we're a modern state. We're not a frontier, group that just came out of the colonies that we were at the founding of the country. The other thing I'll say is in my work, the groups that I tend to like the most, whose sensibilities about this I like the most, tend to be groups that have in their DNA a sense of being a religious minority. And so that's one of the reasons I have great affection for the Seventh-day Adventist Church, for Orthodox Jews, for the Church of Jesus Christ of Latter-day Saints, because all of them, even though they, in some areas, like say Salt Lake City, right, they're a majority, everybody's a religious minority somewhere. You can be a religious majority as an evangelical, non-denominational Christian in Oklahoma City. Go to Portland. You're no longer a religious majority. So everybody's a religious minority somewhere. I was at a conference recently in Salt Lake where it was an interfaith panel, and these were all groups that were religious minorities in Salt Lake City. And they all said they go outside of Salt Lake City and they tell people they live in Salt Lake City, and people say, oh boy, it must be really hard there, to be a religious minority. And what they all said, and this was a rabbi, an imam, and a kind of more what I guess I call mainline, more progressive Protestant, they all said, no, it's actually amazing. It's amazing because the Latter-day Saints, they understand what it is to be a religious minority, and they really respect us. They treat us really well. And so, I do think that's the fundamental thing. I think where I see the kind of lapse into more theocratic impulses, it's where people have kind of forgotten what it is to be a religious minority and why it's important to respect minority rights, to not be coercive toward people. And that is, I think, really what is embedded in the True Religion clauses, non-coercion, right? Yeah. We really shouldn't be coercing people. And it's also embedded in the Religious Freedom Restoration Act. Unless we have a really good reason, we shouldn't be coercing people when it comes to matters of conscience and religion.
Orlin, if you want a really good case study of what Tim is talking about, just go to any number of countries overseas. I worked for many years in international religious liberty, and you encounter countries which have these wonderful constitutions with eloquent protections for religious free exercise that have no equivalent of an establishment clause, that allow governments to put their thumb on the scales in preference for one religion over another in daily life and in laws. And you see there just how vital the establishment clause is in reminding folk that the government is there to do the secular business of governing. It's not there to play religious favorites. And when that sort of government neutrality gets out of whack, that's where you see some of the atrocities, some of the appalling situations that we see in international religious freedom violations. So, there's a lot of rhetoric floating around these days about separation of church and state. I have a feeling that many Christians and many of our political leaders have lost sight of that reality. And I think they need to be reminded.
And by the way, Orlin, it's not just persecution. It's also, if you look at, countries in Europe that have sort of state churches that your taxes go to pay for, the religion is on the decline there. And I think it's because it's just kind of a civil religion. It's milquetoast. It's not thick. And that's also, I think, what happened. So I think the founders, they wanted religion to flourish. They didn't put the Establishment Clause in to keep religion out of things. They did it because they understood from their European history what happens when you have a state church.
Tim, I'm going to let that be the last word, but it seems to me like this concept of separation of church and state, if you play with it too much right now, you'll forget what it may feel like down the road. And therefore, the concept of it is one that we've got to be very, very cautious in how we adjust in any form or fashion. One of my favorite cases that I ever like to talk about is a case that's called Huntsman versus Corporation of the President of the Church of Jesus Christ of Latter-day Saints. This is a case that, ironically, has a member of a church upset because he didn't like the way they used his tithe and offering. And one of the things that happened in the penultimate paragraph of one of the decisions as it related to this particular case, the majority said that they were going to make a decision, but it would not be based on the concept of church autonomy. That's a doctrine that basically we utilize many times to ensure that churches get to do what they want. But the majority explained that this was because its analysis did not want to delve into any church doctrine or policy. And without expressly saying it, what they wanted to do was to claim that this opinion was entirely secular and guided by a religiously neutral principle of law. You know, Bettina, when I hear someone who's supposed to be a jurist talking about coming to a decision through a neutral concept of law, and we look at this particular case where so many church groups were saying, thank God we didn't find a ruling that was going to kill the concept of tithe and offering. However, it seemed as though the court came around to a decision, but then said, but we're still going to keep our hands off of that doctrine as it relates to autonomy of churches. And I believe that all that does is possibly open up the door to have to fight this fight all over again. Or am I missing something, Bettina?
Yeah, there's a huge irony in this case, Orland, because as you point out, Mr. Huntsman was not a happy man. He had tithed substantially over the period of a couple of decades, and he wanted to make sure that, his tithe was being used in the way that he thought it had been represented by the LDS Church. And that was the core of this case. The church made the argument, number one, the court has no right getting its hands messy in doctrinal questions. And second, there is no actionable fraud to be found. And you're right, Orland, the Ninth Circuit en bancs went straight to that second point, that there is no actionable fraud. They skipped right over that church autonomy doctrine. Irony. Great outcome for the LDS Church, because they have now a very clear representation that they did not engage in fraud. Happy days. The problem is exactly as you've pointed out, Orland. Church autonomy doctrine, this constitutional principle embedded in the First Amendment, is absolutely crucial for maintaining institutional integrity for religious organizations, allowing them to live out their faith without the courts engaging in doctrinal arguments. The judges, they went to law school, they didn't go to seminary. And that's the case, that these questions need to stay outside the court. The problem is this case and the way the court approached it seriously erodes that principle.
Yeah, I'll get a little nerdy here on jurisprudence. The case was dismissed based on a ruling of summary judgment, and a summary judgment motion is essentially examined on one standard: is there a triable issue of material fact, and that's the standard. There's no invocation of any constitutional standards or any religious clauses. They're just looking at whether there is a triable issue of material fact. And we have Mr. Huntsman, who is upset that the church was using tithe money to finance commercial development projects, like a shopping mall in Salt Lake City. And so that's the standard that the court used. But going to the church autonomy doctrine, which is based on the First Amendment, that provides that a church can generally spend its money on how it wants. Churches have the unfettered right, of course, to control religious doctrine and define its religious terms. But the question here is whether the Latter-day Saints Church committed fraud to induce its members to donate under essentially false pretenses. So the church autonomy doctrine prevents courts from resolving questions about religious beliefs or teachings. And here the entire Ninth Circuit held that there was no triable issue of material fact relating to fraud, and therefore upheld the summary judgment to dismiss the case.
Tim Schultz, when I look at a case like this and say to myself, it sounded like the court wanted to get involved, but then not get involved. It figured we can speak on this, but we got to speak on it in terms where somebody doesn't come back and say, you really didn't have the right to speak on this. It's almost like they were doing the on the river, on the bank thing there and came to a decision where they said, we're going to bypass where we shouldn't be in this, and we're going to deal with this as being a fraud question.
I think that the court all wanted to say to Huntsman that you lose. So I think part of the problem is this is a kind of gadfly lawsuit by a rich guy who got mad at his church. And he wasn't just mad at them for the way they were. He was mad at them for other things. If you read all of the material about this guy, he became embittered against his church and was trying to get them, right? And I think that this court just was like, buddy, you're not winning. And I think that they kind of chose two different ways to get there, neither one of which I think is going to have a lot of precedential value, because I think this is such a unique thing a guy rich enough and a gadfly enough to kind of pursue his own church in litigation. I think that what hopefully this means is that people who want to sue their church because they disagree with how their church is using the money will just be talked out of it. Now, this guy was rich enough to pursue this, right, to self-finance this lawsuit. But I just hope that this just sort of stands for the proposition, you know what, once you give your money, unless it's just blatant fraud, like you just don't get to go back and say, I want the money back. And, you know, and you certainly can't sue to get the money back. And I think that that's what this case really stands for. This guy, he deserved to lose.
Well, Sharon, I see you smiling. Blatant fraud versus kind of fraud. I mean, where are we looking at this here?
Well, you know, I just thought of something that now I can go. I've had problems with, you know, what we're doing with our tithes and offering at my church. And now I can just bring a suit and say, you know, fraud. But I think everyone is right. I think that the fact that the court actually took it up and made a decision based on there was no fraud, you know, does give people the option, if they do so have the resources to go in there and challenge what the church is doing with its money, rather than doing it through the board of trustees or the deacons. You can actually go into the court and say, you know, I don't think we should be building the playground. I think we should do other stuff or going on this mission. I think that's where it opened it up to going into the courts rather than the church body itself. And I think that's what it could have opened up by the court, not saying, hey, this is not something we should touch. This is something that should be handled internally by the doctrine of the church. And I think that's why folks may look at this, those who have enough money, and try and take it to the court system.
But Bettina, let me ask you this question. Isn't there a point where maybe your church has gone too far? I remember a story of a pastor at a church that I read about where he was getting all of his members to go out and take second mortgages on their homes and decide that they were going to bring that money to support the ministry of the church. And many of those individuals ended up having some financial issues down the road. Some even had foreclosures and things of that nature. It just begs the question that if we're going to throw how a church operates in the category of whether it's fraud or not fraud, it seems that you could be opening up the box for some issues that maybe it's Pandora's box if we start talking about it from that perspective.
And I think this is one aspect of this case which is kind of concerning, and that is the PR aspect, because onlookers, especially those who maybe are not generally friendly toward faith, may say, hey, these are institutions that are above the law, that they can't be held to meaningful account when serious fraud has taken place. And I think that is an idea that we really need to work on to counter, because churches aren't above the law, but courts are not above the Constitution. They cannot delve into spiritual definitions. That they're constitutionally barred from that. But I think you're right, Orlin. It creates a perception, I guess, that churches as institutions that are very jealous for their reputational integrity need to be extra careful. We have, in a way, a higher bar that we need to adhere to preserve the public trust.
Well, Andre, when you look at this, I mean, this is something that took place in federal court as opposed to a local court. It seems the concept of wanting to raise this to the highest level, even the courts decided they wanted to even talk about it.
Right. Yeah. And I serve as general counsel for a religious organization, a Seventh-day Adventist church. And churches, while religious, are corporate enterprises. We're businesses. Churches engage in partnerships and ventures, in many cases related to the mission of the church, and in other cases, catered by the door to make money. And I'm not saying churches should become commercial entities, but the notion that churches should operate in a realm of meager resources is not realistic. We, as our organization does, we are stewards. We're stewards of property. of planned giving and estate planning and and so there's many sorts of areas where churches are responsible for assets and building those assets for the mission of the church. And so I want to just put that let's put this in perspective that that churches, while there to perpetuate mission, is also there for financial survival.
Yeah, I mean, I want to tease Andre a little bit. I didn't expect to hear the Gordon Gekko, greed is good speech from Andre here today. Kidding. But no, I mean, sometimes with religious bodies, you're reminded that you're both a community and a corporation, right? You're when you get big enough, you have an HR department, you have paychecks, you have 501c3 status, like lots of things that are required to do business, and one of those is just being a good steward. I actually think the Church of Jesus Christ of Latter-day Saints is a good steward. I think they spend a ton of money on humanitarian aid for people that aren't in their own faith. They also prudently invest their money, including in commercial development. That to me is actually good stewardship. I think they take stewardship extremely seriously. And I think that, that you shouldn't be allowed to sue because you have a slightly different view of what the stewardship lines should be. That's, I think, what the courts pretty much unanimously agreed with.
And I'm going to make that the last word, and I think that's where we're looking to get to a point where courts understand that what goes on inside the church, they shouldn't have any hands on. We render unto Caesar the things of the Caesar, and just render unto God the things that are God. Hey, Tim, tell me something I don't know.
Orland, multiple studies have shown that the three American religious groups whose members give the highest percentage of their income back to religious causes are three groups that I love: the Assemblies of God, the Church of Jesus Christ of Latter-day Saints, and the Seventh-day Adventist Church.
Wow, did not know that. Bettina, tell me something I don't know.
Okay, we've been talking about the wise use of money. Did you know, Orland, that the US currency motto that we have today, "In God We Trust," is not the original one? The original one was actually determined by good old Benjamin Franklin, and it was "Mind your business." Good advice.
Rashawn, tell me something I don't know.
Well, I'm not sure this is something you don't know, but it's interesting. Of the presidents we've had so far in the United States, the one who governed most as a Christian and through his faith was Jimmy Carter, a Democrat.
That is true. Andre, tell me something I don't know.
Well, coming off of Tim's comment, the Church of Jesus Christ of Latter-day Saints reported an income in 2023 of $31 billion for a total wealth of $265 billion.
Didn't know that either. Great conversation today. Thanks for all the knowledge. And thank you again for being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.